Welcome to the Whistleblower of the Week podcast, hosted by FBI whistleblower Jane Turner. Join her as she shares the stories of real-life heroes and people of integrity.
Hello, this is Jane Turner with Whistleblower of the Week, and I have an incredibly distinguished guest joining me today. I am really thrilled to have on Andrew Feller. He is the Senior Special Counsel at Kohn Colapinto in Washington, D.C. He's had 20 years of experience in securities and commodity law. 15 years went to the SEC, which is the U.S. Securities and Exchange Commission, and he's been investigating and litigating securities fraud during that time. Andrew was a founding member of the SEC's Complex Financial Instruments Unit in the SEC, and in this role, he brought major cases against large international banks stemming from the 2007-2008 financial crisis. Andrew also played a key role as a founding member of Enforcement's Retail Fraud Task Force in 2018. Something else that I'd like to note, which is pretty incredible, is that Andrew also worked from 2019 to 2022 as SEC Senior Counsel, Senior Policy Advisor to SEC Commissioner Allison Lee. So you were right next to the heartbeat of power there at SEC. Welcome, Andrew, to Whistleblower of the Week.
Thanks, Jane. I'm really happy to be here, and I'm looking forward to our conversation.
I'm thrilled to have you because of the experience you have, especially in SEC in the area of securities and commodities, because so many whistleblowers come through that area, don't they? And there's some huge awards that are possible.
Yeah, both the Securities and Exchange Commission and the Commodity Futures Trading Commission, the CFTC, have pretty vibrant award programs that have been, to my mind, incredible successes in incentivizing whistleblowers and producing results.
And I think, and I'm going to just ask you a few questions here, Andrew, because this is really fascinating. How did you get into this role? I mean, people would say to me, geez, I could never be an FBI agent. And I think, geez, I could never be a litigation attorney. So tell me how you got to such high pinnacles of success. Tell me your law school.
So I went to the University of Michigan Law School, and from there, pretty standard story, went out, worked at a couple of big law firms for about 4 years. And then from there, I saw that the people who I thought did the best job of defending companies in SEC investigations were people who'd been at the SEC. So when they started hiring around 2007, I made that jump. I should say, with the support of the person I was working for at the time at a private law firm, who went on in recent years to become the Inspector General of the Veterans Affairs, and was one of the people one of the Inspectors General recently purged. So he was a great mentor to have, and he encouraged me to go into government service. So in 2007, I went over to the SEC, and you went over a couple of my talking points. I did a number of cases growing out of the financial crisis involving big financial institutions. That led me to be one of the founding members, like you said, of the Complex Financial Instruments Unit, which was a group of people who had worked on some of those financial crisis related cases. And I should say, with respect to that the creation of that unit was part of a set of reforms that came after the sort of twin crises of the financial crisis and the Bernie Madoff scandal at the SEC. There was a perception and probably a reality that there was a need for some significant structural reforms. at the SEC. And among those were both the creation of these units, including the one I was in, as well as the creation of the Whistleblower Program. And those two came in around the same time and were fairly complementary. There was not only a solicitation of whistleblower tips, but also now places for them to go where they would be reviewed and worked with by people who had specialized knowledge in certain areas. So I did that for a number of years. In that time, I moved from the DC office of the SEC up to the Boston regional office. So I've worked in both the home office and the regional office of the SEC. Moved over to the retail task force to get a different kind of experience when that was founded. And then in 2019, as you mentioned, Allison and Lee, who had been a colleague of mine in the complex financial instruments unit, became a commissioner. And I had the opportunity to go work as her counsel, and I jumped at that opportunity. So for 3 years, her entire term, I got to do that. She is a dear friend. She was a great boss, and I am happy to say she's also now a colleague at Kohn Colapinto. Yes. We are the co-chairs of the Securities and Commodities practice here.
Andrew, tell me, because I'm very curious, you have the institutional knowledge to kind of shine a flashlight into the SEC during the time it turned into a juggernaut. I mean, bringing in these huge penalties. And I assume that you and Allison and your colleagues were responsible for that. I mean, it's just a juggernaut that they've turned into. You obviously did you work with people like Senator Grassley, and did they help you bring about this massive program? Or who was the brains behind this?
So the program was founded in around 2010, 2011, when the Dodd-Frank Act was passed, and then they passed some rules that codified the program at the SEC. Senator Grassley obviously has been a champion for whistleblowers and for government whistleblower programs, and has been, I think, in the background helping to strengthen these programs through legislation. When I was a staff attorney, you don't work closely with the Senate. You don't sort of see how the sausage is made on the rulemaking side. You just do it. You do the cases. And I got to work with a lot of whistleblowers, and I got to see the program develop. And really, in a very short time after it was implemented, it became a cornerstone of the SEC's enforcement program. Just the number of cases that are based on whistleblower tips, it hockey sticked. It went from nothing to probably the most important source of cases for the division. And I saw that happen because that was when I was in enforcement. When I went to work for Allison, that's when you start to get involved in some of the rulemaking activity, engagement with Congress, and I got to see another side of it. And it's been a real privilege getting to work with the people who make it run, work with the people who have done a lot of thinking about how to optimize the program, and to work with, that was my first opportunity to really work with a number of the people who, from the whistleblower bar, who were engaged in policy discussions trying to strengthen the programs across the government, including Steve Kohn, who's obviously a named partner at my current firm.
Yes, and I believe on these policy directives, you had a couple of hands that helped you, obviously, but you guys were really the spear point, weren't you, in getting these programs created and having this massive return, which I don't think, did you expect that?
Well, again, I was just investigating cases when the program came in, but I don't know that anybody anticipated just how successful the SEC program would be. it like I said, it sort of started to swamp everything else in terms
Right.
of where cases came from and where quality cases came from. There was a real demand, it seems, for a place for whistleblowers to come with a confidence that they would be both received by someone who knew what they were getting, and also that their anonymity and confidentiality would be preserved in a strong way.
Yeah, and the cases you worked on were like against UBS and Putnam Investments, Citigroup. It's just amazing what you had your hands into. These massive cases, 285 million being returned to investors.
Yeah, I'll tell you what's amazing is if you talk to anybody who worked in enforcement for a long time, they've all had amazing cases. There's just I, I can't say enough about um, my strong feelings, strong positive feelings about the SEC, the work they do, the Division of Enforcement in particular. It was not just an incredible experience for me, but when I look around, it's pretty humbling because I thought I was okay at it, but there are a lot of people
Mhm.
there who are really, really good at it.
And
And go ahead.
no, no, and so I was wondering, what is the future looking like for these programs? Because I've talked to whistleblowers who are extremely concerned that it might be gutted, that people might be let go. Do you have any inside info on that?
Well, I wouldn't say I have any inside info. I have concerns. I have expectations. I think that there has been strong bipartisan support for the whistleblower program. Uh, there's been strong support from the current commissioners at the SEC, but that doesn't mean that the program itself uh, won't suffer if there's sort of large scale cuts of staff, of resources, because the success of the whistleblower program really depends on support, not just rhetorical support, uh, but the right people, the right
Right.
technology, the right set of resources to continue to make the program work efficiently. I mean, a big part of the success of the program is whistleblowers having being incentivized to take on the
Hmm.
risks, to take on the burdens of blowing the whistle. And if there's inefficiency in the enforcement process, if there's inefficiency in the awards processing process, I think then you start to worry about the incentives for whistleblowers as they look and say, is this going to be worth it for me?
And that's kind of really interesting because, last summer I was over in the UK and they look at your program as the shining star of the North. And they're doing everything in their power to replicate it. And they're not the only ones. I'm familiar with other nations who are just gung ho to embrace the program you guys set up and proceed with it. So if anything happens to this program, it will be a shame. But can you tell us, Andrew, about kind of an overview of the SEC Whistleblower Program? Tell me what your experience has been working with that program, both while you were at the SEC and now at Kohn and Colapinto, where you're representing whistleblowers.
Yeah. So in broad strokes, the SEC's program uh, provides awards up to 30% for whistleblowers, 30% of amounts recovered in any action based on the information that a whistleblower brought to the SEC. The The program's administered through a dedicated office at the SEC called the Office of the Whistleblower, which we refer to as OWB. And they act as both a point of contact for whistleblowers and also the people who they are the people who process award applications and make preliminary determinations of the amount that should be given to a whistleblower. The commission itself, the 5 members of the Securities and Exchange Commission, are the ones who vote on final awards. But OWB is the one that does the heavy lifting of putting those together. The program's run pursuant to a set of rules that was adopted under the Administrative Procedures Act, regulations that under the 1934, the Securities Exchange Act of 1934, and those rules codify both eligibility requirements for whistleblowers, award criteria. I should have said both, but there's more than that. Award criteria, as well as some of the rules that apply to what we call anti-retaliation provisions. So, in addition to the awards, the rules both prohibit companies from retaliating against whistleblowers, as well as prohibit measures intended to prevent people from reporting in the first place. And so you can think of the SEC program as having those two parts, which is on the one hand protecting whistleblowers, and on the other hand awarding them for their information. So two really important pieces.
Yes.
My experience working with whistleblowers at the SEC is there's a tremendous amount of support within the agency for hearing out whistleblowers, for reviewing the information that comes in, and I think there's a reasonably good, a pretty good infrastructure within the agency to ensure that whistleblowers are heard, that their tips go to the right places, that they're handled with the appropriate seriousness. There's always room for improvement in anything, but
Yeah.
I think that whistleblowers should feel pretty good when their tips go into the SEC, that very smart people are going to take them very seriously. That doesn't mean there'll always be something that happens as a result of it for a variety of reasons. But in my experience, they're taken very, very seriously.
That's good to know, Andrew. Yeah, I'm sorry, I didn't mean to cut you off, but do you recommend that a whistleblower get an attorney in order to provide the information to SEC, or should they just file by themselves via the computer or something else? I'm a big proponent for whistleblowers getting lawyers and attorneys, because it's a labyrinth, of regulations, protocols. It's impossible to figure out.
There's a pretty wide variety of experiences people can have, but I think that having a whistleblower lawyer can be really helpful to navigate the process, and also to help in the end to advocate for the whistleblower to get the best award they can. The process includes both the beginning of getting the information into the SEC in a form that will make the SEC understand the significance of it, and then working with the staff through an investigation, and in the end, advocating for an award on behalf of the whistleblower. So it's a lot to take on for someone on the road, almost like any interaction with a regulatory agency.
Yes, almost as bad as having a baby, and I've done both. So it can be a gruesome procedure.
I'm a strong no comment on any of that.
Okay. What protections does the SEC Whistleblower Program provide for whistleblowers? I mean, this can be a dicey journey, and
Sure.
some of
Yeah.
them have big institutions, huge institutions that they're giving information about.
Yeah. So there's a couple of different things. There's what I call the anti-retaliation rules, which are prohibitions on companies taking any action to punish, and that's broadly defined to punish someone for being a whistleblower, and that creates what we call private right of action. A whistleblower who's retaliated against can actually sue the company for those acts of retaliation. We'll talk a little bit about the limitations on that, but at this point, that applies to people who have actually reported to the SEC, blown the whistle to the SEC. There's also rules against trying to prevent whistleblowers from blowing the whistle. Those, again, are pretty broadly defined. Those are enforced by the SEC against a company. That's not something that a whistleblower would have a right of action on their own. That is another regulatory violation that the SEC would bring a case against a company for.
So, Andrew, does that even apply when the whistleblower is in another country?
It does. It does. There's nothing that limits it to people in the United States. Now, to be clear, I think that would depend on who their employer is. The company would have to be, I think, a United States company, one within the jurisdiction of the SEC. But whistleblowers from around the world can report to the SEC and have at least some of the anti-retaliation protections.
Which is excellent. In 2018, the Supreme Court ruled in Digital Realty versus Summers that these anti-retaliation protections in the Dodd-Frank Act, which created the SEC Whistleblower Program, do not apply to corporate whistleblowers who report securities violations to their employers, company hotlines, or other internal methods. Can you tell us what impact of this decision, what the impact has been of this decision?
Sure. I want to amend my previous answer briefly,
Sure.
which is
Sure.
which is to say that a non-U.S. whistleblower is there are protections if the company is a U.S. company, then they are still prohibited from taking action to prevent that whistleblower. The non-U.S. person probably does not have the private right of action against their employer for retaliation, unfortunately.
Good to know. Good to know. These things are important. And we do have people from other nations that listen to this podcast, so good to know.
So Digital Realty.
Yes.
It was a bit of a surprise and a disappointment when it was decided. The SEC had taken a different view of the meaning of the statute, but the Supreme Court decided that the plain meaning of the statute in their reading was that only whistleblowers who had reported to the SEC were eligible for the anti-retaliation protections under the law. And the Supreme Court based that both on what they viewed as the plain language of the statute, as well as what they interpreted as the intention of the whistleblower program, which they said was to encourage reporting to the SEC. But the irony there is that organizations like the Chamber of Commerce advocated on behalf of Digital Realty, the company that had retaliated in that case, and said, well, they should not be liable for retaliation here. But those same organizations had expressed a concern at the founding of the whistleblower program that it could potentially undermine corporate compliance programs. But what the Digital Realty decision does is essentially requires a whistleblower to go to the SEC and go around to skip the step of going reporting internally to a compliance program. So it disincentivizes internal reporting. So it's a very strange thing to have for some place like the Chamber of Commerce to have advocated that position, because it undermined what had been their previous position.
And why do you suppose that is? I mean, whistleblowers have an uphill battle in the first place, but I noticed the Chamber of Commerce doesn't always seem to be favorable to whistleblowers. That's just my personal opinion. But
no, and I think my sense is that it was a little bit of losing the forest for the trees. There was a desire to support a company that was fighting off a claim of retaliation, but the long-term effect of the position they took was to really undermine, in a way that the whistleblower rules had not been previously, to undermine corporate compliance programs by really creating a strong incentive for a whistleblower to go in the first instance to the SEC so that they would be protected.
The interview will continue after this brief message. Become part of the growing grassroots movement that supports whistleblowers around the world who risk their careers, financial security, friendships, and even their freedom to speak out against wrongdoing. Make a one-time gift or become a monthly donor today. Every donation makes a difference. Visit whistleblowersblog.org to give.
Could you tell us a little bit about that case for the audience? Can you just tell us what it was about?
It was pretty straightforward. It was an internal whistleblower at a company who had reported, I believe, through a hotline, and was ultimately demoted and fired, and sued for retaliation, and had believed that he would be eligible for those anti-retaliation protections under Dodd-Frank. That had been the interpretation the SEC had previously taken, and it was sort of the logical position for just the reason I'd been saying. But the Supreme Court decided otherwise.
What do you suppose was behind that Supreme Court decision? I mean, I know none of them have been whistleblowers, but certainly the antecedent messages out there from whistleblowers is that when they, tell their story inside the company, retaliation follows because they've just identified themselves. So
it's
why would they rule?
It's hard to understand why the Supreme Court does all the things it does, but I think in that case, their reading of the statute was understandable, if also very strict. And part of the issue was that Congress needed to draft a little more carefully to make sure that they accomplished the things that to my mind they were trying to accomplish.
Did Congress do that?
Not yet. Okay. Not yet.
And I know this, I don't want to out you, but are you currently working with Congress to get that brought about?
There are people from the whistleblower bar that are working closely with Senator Grassley and others to see if we can't find a solution to this issue.
Because hasn't it created a chilling effect for corporate whistleblowers, this ruling?
So it's interesting. I was thinking about this question. It's difficult to quantify any sort of chilling effect, but I I think it's safe to assume that uh, given that even though reporting to the SEC is not super difficult, particularly if you're working with a whistleblower lawyer, it's still yet another step. And if there are people who are inclined to blow the whistle, but don't want to take that extra step, or and I've worked with a number of whistleblowers, people who have a real um, attachment to their company,
Yep.
and are really trying to save the company from itself. A lot of them would prefer to report internally. I think there are a number of people who uh, really wish they could get the company to listen and to
Hmm.
address the issue. And I think it's unfortunate if they're disincentivized from doing that, along with reporting to the SEC.
Right. And that's so I can kind of glean from your answer that there has been kind of a chilling effect.
I would think so. I would think so. Like I said, I think it's very difficult to quantify. I think because whistleblowers, someone who doesn't blow the whistle,
Hmm.
is very hard to identify, right? Um,
Right.
so so measuring the chilling effect is going to be difficult because it would depend on identifying people who, by definition, you can't identify.
Right.
But I think it's fair to assume there's been a chilling effect from it.
So Andrew, tell me, if you have a whistleblower who you talk to on the phone and they're in a corporate structure and they want to blow the whistle, do you have to inform them they have to go through the corporate structure first before they
No,
can? Okay. Tell
no,
us
not
the
at all.
difference there.
So the SEC's, I mean, we haven't, I think you've had previous podcasts that have gone through some of the details of the SEC's rules, but the SEC doesn't require corporate report, doesn't require you to report internally to be eligible for an award. And moreover, it doesn't penalize you for not having
Good.
reported internally. That's slightly confusing because you can also be, um, it is considered a plus factor for a higher award to have reported internally, but there's nominally no penalty for not having done it. How that works is a little metaphysical, I think, but
Right. But in my practical experience, corporate whistleblowers, if they do report inside, they're subjected to these incredible retaliations. We have names for them, but you know what they all are. And
yeah, and so that was what I was going to say in response to your
mhm,
question about what you would tell them, what I would tell someone on the
right,
phone, which
right.
is to lay out very clearly that first of all, the rule is that they're not going to be eligible for protection, for anti-retaliation protection, unless they report directly to the SEC. And
Oh,
second, that in many cases, I don't want to paint with too broad a brush. There are many cases in which people are retaliated against and for reporting internally. There are also companies that take very seriously the need to um, listen to and protect internal whistleblowers. Unfortunately, it's going to be pretty hard to determine before you do it which kind of company you work for.
right. So give a little advice to a whistleblower who's listening today and they're trying to figure out if they should report it to the SEC, if they should go to their manager or upper structure of the corporation, what advice would you give them? And they're sitting on it right now, corruption, criminal activity. What advice would you give them?
I would strongly suggest that they report to the SEC because the rules as they're currently written won't provide them the protection they should have from retaliation without reporting to the SEC. I think they also should consider the possibility of getting an award because they may very well be subject to a great deal of stress and potential retaliation, and they should be eligible for some compensation for that. They're doing an important thing, and it takes courage, and it can have consequences. And that's why we have this program.
Excellent point. Excellent point. And Senator Grassley recently reintroduced the SEC Whistleblower Reform Act. Can you tell us about what's in this bill and why it's important? And bless Senator Grassley. We call him the patron saint of whistleblowers. So may he live a long, long, distinguished career. Go ahead.
So the bill, which I think he introduced initially last year, and it didn't end up getting acted on, and is going to hopefully be reintroduced this year, does three things. The first is to correct or fix the issue that we were just discussing that was created by the Digital Realty decision, and to provide the same anti-retaliation protections to internal whistleblowers as currently apply to SEC whistleblowers. So that would both address the sort of perverse incentive that was created by the Digital Realty decision, and also I think a lot of people who do blow the whistle internally, possibly before speaking with a whistleblower attorney, may not understand that they're not going to have those anti-retaliation protections.
Right.
And it's really important that the rules line up with people's expectations in that way. I think there have been a number of people, starting with the plaintiff in, or I guess the employee who was retaliated against in Digital Realty. The second thing the whistleblower reform bill would do is to put a 1-year clock on award applications, so that the SEC would be required to issue what's called an initial determination, and that's issued by the OWB. It's an initial assessment of the award application and how much a whistleblower should get within 1 year of the application. And that would be, the bill includes provisions for that 1 year period to be extended by the director of the Division of Enforcement in cases that are particularly complex or there's other good cause. But generally, it would try to put a clock on that. And that's a reaction to the really long waits that a lot of whistleblowers have had for awards, which is really, really unfortunate. It's bad for the whistleblower. It's bad for the SEC because, again, it disincentivizes whistleblowers, and the SEC depends on whistleblowers. And this goes back to the resource issue that we were talking about in the beginning. Moving these applications through requires the Office of the Whistleblower to have adequate resources. The more whistleblower tips there are, the more applications there are going to be for awards. And that's just going to increase and has been increasing. And so there's a really basic manpower issue behind that. There are also a lot of complex legal issues, and the SEC needs to dedicate appropriate resources to that, and hopefully, my hope, speaking for myself, is that that kind of mandate that's in the whistleblower reform bill would be accompanied by some action on the appropriation front to ensure staffing and funding for the whistleblower office to meet those deadlines and accelerate the processing of awards.
Totally agree.
The third thing that the bill would do is to prohibit companies from attempting to force employees to waive any of the rights under the whistleblower rules. And so this would be in any type of agreement, whether it's a settlement agreement of some sort, an employment agreement, anything that says you agree not to collect an award if you report to the government. There have been a lot of companies that have attempted to include provisions like that in a variety of different types of agreements, and this would prohibit that kind of thing.
Wow, that's pretty cheeky, don't you think?
If you ask me, yes.
But, okay, pretty cheeky. I'm sorry. Go ahead.
No, go ahead, please.
Okay. In the tons of whistleblowers, and when I say tons, I do mean it. We've had hundreds that I've talked to, and the thing about the SEC that gets most of them is the wait. It seems to take forever. But isn't that another good reason to have an attorney? Because they don't seem to get far when they represent themselves. They can't get much communication, it seems like. Your attorney appears to get a better response from the SEC.
I think that people who work with the SEC a lot, whether it's on the defense side or as a whistleblower or a lawyer, are able to develop both relationships with the staff as well as a sense of how to navigate the process, whether one type of letter is more effective than another, whether multiple filings versus some sort of informal communication might be better. There's just, as with anything in life, when you do something over and over, I think you start to develop a feel for it. That's at least the theory behind what we do. And you add to that bureaucracy, which is just a fact of life when dealing with a regulatory agency, and navigating that's not always easy. And so I think that whistleblowers have enough on their mind to not necessarily need the additional burden of trying to figure out how to navigate that process.
That is wonderful advice. I mean, it just rings very, very clear. May I ask how two blue ribbon attorneys like yourself and former Commissioner Lee ended up at KKC? How did they bag two of the highest, most experienced and blue ribbon commodities attorneys? How did that happen?
So I wouldn't dare speak for Allison, so I won't do that. But I can say for myself that I got to know Steve and some of the others at KKC when they came in to advocate for some rule changes when Allison was a commissioner, as well as the acting chair of the agency. And I was impressed by the dedication Steve showed and the firm showed to not just zealously representing their whistleblower clients, but also working on behalf of the whistleblower community, the whistleblower bar, to improve the rules and really engage substantively with the policy process, which to me is something I want to continue doing in this role. The other thing I'll say is that I've been around the SEC a long time, and
Mhm.
there's not a huge variety in the paths people take out of the agency. And I wanted to do something a little bit different. I hadn't seen many people do it. I knew it was the area of law I wanted to practice. It was the thing I felt passionate about. And I wanted that path to be visible to people who came after me. And so we'll see if there's more movement of people from the SEC into the whistleblower bar or other alternatives like the plaintiff's bar. But that was something that was important to me, and was one of the things behind my move.
And I'll tell you, whistleblowers appreciate that more than you'll ever know. Because really, before you and Ms. Lee, they weren't bound to come in and help whistleblowers, employees of the SEC. So you two are really charting a new path, aren't you? I mean, I think it's
Not,
wonderful.
it's not entirely new. There are a few people who've done it, and I'm glad they did. Uh, but it's a great opportunity working together again to pursue some of the things that we were both passionate about, and that align with I think the values that we brought to the work we did at the commission. I think both of us were looking for opportunities to not be adversarial with an agency that we both have a deep connection to.
I'm just delighted you're with KKC and you're helping whistleblowers. May I ask if there's a whistleblower listening and wishes to contact you, is there a way they can do that?
Well, I think the best way is to go through the KKC website. We have a really good process to do a thorough review of any intake. They can also, I have a email address on the website. They can reach out through that or through our intake form. And everybody who reaches out gets a really careful review of what they're bringing, because we know what a serious step it is to think about
Oh,
blowing the whistle.
oh, exactly. And if a whistleblower, someone who's thinks that they could become a whistleblower in the corporate setting and is sitting on the fence right now, what kind, trying to decide, should I not? What kind of advice would you give them?
Call a lawyer. There's people who know, who've talked to a lot of whistleblowers, who've worked with a lot of whistleblowers, who've worked with these agencies, and who've navigated this process. And it's not always easy to do it on your own. And we're here to work with you. Our incentives are aligned with yours. And this is what we do.
Thank you, Andrew Feller. You are really an inspiration and advocating for whistleblowers, experience with the SEC. Can you give us any closing thoughts or words? Because this has really been valuable.
So thank you for having me. It's been a
Mhm.
treat to be on, and I've really enjoyed it. Final words are that I'm really honored every day to get to work with whistleblowers, to get to work with passionate advocates for whistleblowers, and I hope that people will continue to appreciate uh, both the brave actions of whistleblowers as well as the hard work that the government puts in to treat them with the respect and seriousness that they deserve.
Thank you, Andrew Feller. You are remarkable.
Thank you for listening. Please remember to like, comment, and subscribe. You can find more whistleblower stories at whistleblowersblog.org. Music by Rachel Kilgore, guest booking by Victoria Thompson, and editing by Anissa Cheek. Whistleblower of the Week is a production of Whistleblower Network News. The views expressed by podcast guests are their own and not those of Whistleblower Network News.